All right, it's been a while since I did a stream, and since videos take an awful lot of time to do, I thought I would throw some ideas into a stream rather than trying to structure them too much. And what I'm going to do now is look at an article I've been reading, I just came across, and it's called The Aesthetics of Law and Literary License, An Anatomy of the Legal Imagination by J. Julia Shaw. It's apparently published in Liverpool Law Review. And what I'm going to look at is what the author has to say about how legal principles, statutes, judicial pronouncements use rhetoric, use aesthetics, use literary conventions to control. And let's just see what she has to say here. As a normative discipline, law defines its territory according to symbol categories which establish absolute principles, purporting to offer a single truth as to what is just and unjust. Let's go down a bit more here. Yet still founded on the negation of its own history, legal practice maintains that juridical arguments comprise only dialectical reasoning about objectively determined concepts. Law is a literature which denies its literary qualities. It is a play of words which asserts an absolute seriousness. It is a genre of rhetoric which represses its moments of invention or fiction. It is procedure based upon analogy, metaphor, and repetition that lays claim to being a cold and disembodied prose. That's really interesting because although she comes at this very much from a leftist power perspective, what I'm going to do after I get through this article, I'm going to look at some legislation and just see if the underlying power is using language to create a narrative that may be making what's real unreal, moral immoral, and vice versa. Anyway, let's look on. So here into the introduction. Here we go. Let's look at this bit here. Close examination of legal practice reveals a set of profoundly aesthetic characteristics, specifically literary tropes, which are habitually associated with authority and reason. There are clear connections to aesthetic matters, for instance, obscenity laws, municipal aesthetic regulations, copyright, environmental law, the representation of rights and issues of textual interpretation. Aesthetic dimensions are also claimed to lie at the very heart of law and justice, to the extent that legal discourse is asserted to be fundamentally governed by rhetoric, metaphor, form, images, and symbols, which can illuminate both the meaning and force of law. As well as being portrayed as a form of literature, the debates among major jurisprudential traditions can be viewed as aesthetic contrasts among competing narrative methods and visions, and some debates within major jurisprudential traditions can be viewed as contrasting aesthetic mixtures of vision and method within major narrative categories. The cognitive processes that govern our thoughts and actions are not purely matters of the intellect. As aesthetic concepts, they structure experience, shape perception, and mediate our relationship with others by constituting reality. In support of this thesis, a growing body of scientific evidence from cognitive psychology and neurobiology has recently proposed that aesthetic forms of knowing precede other forms and significantly influence how they function. Let's read all of this bit. American pragmatist John Dewey described the aesthetic as extending to everyday experience and as having a close connection to morality. He emphasized the continuity between the refined and intensified forms of experience that are works of art and the everyday events, doings, sufferings that are universally recognized to constitute experience. In a late essay, Immanuel Kant acknowledged the usefulness of an aesthetic methodology, which was receptive to the form and imagery of legal concepts, but warned against the possibility of the presentation of the supersensible, and more specifically, the aesthetic manner of personification, personifying the moral law as a veiled Isis or veiled goddess. Here we go. Pierre Schlag further maintains that law is an aesthetic enterprise. Before the ethical dreams and political ambitions of law can even be articulated, let alone realized, aesthetics have already shaped the medium within which those projects will have to do their work. I'm going to get into the next section on law and aesthetic enterprise. Whilst aesthetics is considered by legal practitioners to be extraneous to morality and ethics in the formulation of law, the narrative form and figuration can obscure an underlying structure of oppression, as well as nurture a real sense of unity and common purpose. Now, to be clear, over and over, the author is looking at the manipulation, if we can call it that, use of language to enforce a right-wing agenda. But what I'm going to show at the end is this can be used by any power, the use of language to manipulate and to make legal principles which appear to be one thing, actually enforce another narrative. The creation of a link between justice and beauty is argued to arise from the enriching asymmetry of the encounter between law and aesthetics. However, this encounter could just as easily produce an unjust or ugly connection. For example, the aesthetic fabrication of legal truths, such as equality of all before the law, with the promise of impartiality portrayed as the blindfolded Roman goddess Justitia, holding a set of scales and an unsheathed sword, appeals to an innate desire for justice as fair, swift, and final. The allegorical personification of justice for all gives shape and form to abstract notions of fairness and equality in lawmaking and adjudication, and importantly, appeals to a call for social justice and the basic human need to belong to a community of equivalent others, which in turn nurtures a culture of compliance. To maintain the illusion of communal cohesion under the law also requires a sophisticated process of rhetorical dissimulation. And that's what we'll look at when we look at the medical assistance in dying legislation. Are they using rhetorical dissimulation? Continuing on, which makes it possible to mask the exacting and coercive ideological standards, which in reality locate the subject outside the law within the context of an exclusionary and socio-symbolic schema. Now that's lefty language if ever you heard any. Let's just get to the bottom of this. We will get to the bottom of this. Through various speech acts and experiences, the cultural constituents of legal identity are signaled aesthetically in the sense that a feeling for law, particularly law as justice, arises from within the context of the imagination, a capacity shared by all human beings in ordinary life. Austin Surratt and Clifford Geertz refer to, respectively, the imaginative life of the law and the way law lives in our imagination, and that here, there, and everywhere, law is part of a distinctive manner of imagining the real, whilst relying predominantly on denotative interpretations of law. Legal practitioners, particularly members of the judiciary, have habitually employed imaginative literary devices to exploit and manipulate the latent potential of figurative language. The cognitive function of metaphor, for example, is to create an opportunity for modifying the conceptual frameworks used in sense-making. Metaphors such as the floodgates produce a special effect by conveying connotative meaning, which enriches the text and renders meaning more precise and determinate. Equally, picture language has the ability to easily communicate ideological propositions which support the values shared by the legal community, and being semiotically loaded and subject to aesthetic interpretation, it has the capacity to elicit a cohesive sense of belonging and significantly legitimize the authority of law, estranged from material life and set over against it as a commanding force of the law, political state, and other institutions of control alike. Herbert Marcuse asserted that every structure of domination has its own aesthetics. And of course, as we know on the left, as we know of the left, when it's asserting one thing, you keep a close eye out for inversion, meaning they're accusing you of doing something they in fact are doing. Now, this is an interesting bit, like from a feminist perspective, how they view reasonableness. As an important component of law's aesthetic armory, metaphor melds intellect and world, sign and object, cognition and appearance in an illusion of unity, because while constructing likenesses between categories, it can just as readily dissolve difference. Consequently, distinct classes identified by, for example, race, gender, and sexuality may be excluded. Just as one of law's most enduring legal fictions, the suspiciously masculine reasonable person standard for many years embodied a gendered interpretation of reasonableness. Well, question it all you want, but how about add vax status to the list here and see if you can't see the application of this kind of power in judicial decisions, in law, in action, but very much on the other side. I just want to read this little excerpt here. Consequently, the activities which make up the professional life of the lawyer and judge constitute an enterprise of the imagination, an enterprise whose central performance is the claim of meaning against the odds, the translation of the imagination into reality by the power of language. Legal discourse comprises many different voices, from the legal specialist and expert witness to the layman as jury member and claimant. And as a litigator, one devises a theory, then presents that theory and tries to get the finder of fact to accept it. So you are a storyteller, believe it or not. Anyone who practices law knows that. You tell stories, especially if you're a litigator. Okay, let's look at this. I think I'm on the wrong page. Just one second. Let's read this. As an important component of law's aesthetic armory, metaphor melds intellect and world, sign and object, cognition and appearance in an illusion of unity. Because while constructing likenesses between categories, it can just as readily dissolve difference. Consequently, distinct classes identifies, for example, race, gender, and equality and sexuality, which I've done already. Just one second. I lost my spot. Here we go. Sorry. Irony, character, metaphor, and allegory, or false semblant, were fundamental concepts of 16th and 17th century court culture, and the skillful deployment of figurative language was likened by Elizabethan lawyer and alleged author of the anonymously published 1597 Arte of English Poesy, George Putnam, to the art of duplicity. He used the classical maxim qui necit dissimulare necit regnare, using that's church Latin. Who knows not how to dissemble knows not how to rule, to suggest that all successful sovereign authorities engage in the habit of dissimulation, implying that the mystic foundation of law's authority may be little more than trickery, lies, and deception. There's more to it than that, but the key is to understand that you are being manipulated, especially in the modern total state, as we will see. A significant part of our vocabulary originates from metaphor. And this is under legal aesthetics and culture, the metaphorical masks of the law. Let's look at this little bit here. Here we go. For the modern lawyer, the influence of metaphors, myths, and symbols in their deliberations has been described as unavoidable, as metaphor and narrative act as ideological baggage carriers that transport messages without conscious discussion, because meaning is constructed, and metaphor and narrative are the frameworks of its construction. As Lon Fuller stated almost 90 years ago, metaphor is the traditional device of persuasion. Eliminate metaphor from the law, and you have reduced its power to convince and convert. According to 18th century jurist and political philosopher Giambattista Vico, metaphor preceded denotative language, as early humankind communicated via images transposed into expression. As Albert Camus wrote in his notebooks of 1935-42, feelings and images multiply a philosophy by 10. People can only think in images. If you want to be a philosopher, write novels. Franz Kafka's The Metamorphosis, George Orwell's Animal Farm in 1984 famously illustrate the proficient use of extended metaphor to satirize, respectively, the fragile nature of identity and human relationships, Stalinist Russia and the rise of totalitarianism, and a dystopian society where totalitarianism has taken over. And we should be able to see this in current laws that are being promulgated in the West, because of, if I'm right, if my thesis is correct, that we're living in a total state at the moment where a massive amount of power has been concentrated, and the state is maintaining its power through the kind of dissimulation we're looking at. So the deployment, here we go. So the deployment of metaphysical masks of law, such as in establishing legal personality, also enables the construction of legal identity by obscuring the true self and replacing the authentic individual with an idealized representation. Jumping down a bit, and we can skip this part. This gets into some history, which is pretty good. Looking at these concepts of the dual body of the king. This is all super interesting. I just want to get to a speech by Elizabeth I. This is kind of cool. And you can see in Elizabeth's speech, she's communicating much more than she's saying. Elizabeth I, this is before the Spanish Armada, when the Spanish Armada was threatening. And I think Neil Oliver just dealt with this recently. Elizabeth I accepted the metaphorical endorsement of misogyny, customarily referring to herself as king, in a famous speech to her troops in 1588 at Tilbury, prior to an invasion of the Spanish Armada, which never actually happened. She declared, "I know I have the body of a weak and feeble woman, but I have the heart and stomach of a king, and of a king of England too, that any prince of Europe should dare to invade the borders of my realm, to which rather than any dishonor shall grow by me, I myself will take up arms. I myself will be your general judge and rewarder of every one of your virtues in the field. As well as displaying her mastery of persuasive rhetoric by first appealing to the commonly held view of female feebleness, Elizabeth was then free to continue with bold masculine pronouncements, using the metaphors of heart and stomach, symbols of courage and loyalty, which demonstrated her commitment to traditionally male virtues. And quite interesting that language will and can enforce a commitment to virtue, call it male virtue. And if you're going to change the virtues, the language is going to change. And we certainly see that in the modern therapeutic state, where we see more language of care and health and safety, the kind of language you simply would not see under a different regime. Nevertheless, such as was the power of the prevailing masculine monarchical metaphor, that Elizabeth felt the need to renounce her female body by choosing, shortly after her coronation, to remain unmarried, and thus ensured she would always remain king and never be diminished to merely the wife of a king. Legal texts offer many examples of aesthetic contrivances in a variety of forms. Let's look at law as a metaphorical language. I'm going to skip most of this as time is pressing. Skip all that. Go down to the bottom of this page. Here we go. Since narrative and counter-narrative, heroes and villains, categories of judgment, crimes and punishments are all produced by the creative use of the legal language, constant vigilance is required as to how metaphors are formed and the circumstances of their implementation to ensure their associations are always legitimate and constructive. And whatever the legal or the political persuasion of the author, that is good advice. So look carefully at how laws are written and what they're telling you. Legal truths, moral metaphors, and moral panic. This is good stuff. And you can actually, although she's talking about the Bush era, war on terror and stuff, this all applies to what's been going on in the last few years under a very different regime, you could argue. Let's look at this. Metaphors are commonly taken for granted and treated as expressions of literal truth. They have a compelling representational function, standing in for or substituting the very things they merely symbolize. As metaphoric speech deviates from the ordinary use of language and is capable of expressing higher order values, Aristotle cautioned that a sense of appropriateness for the occasion, audience, and situation was necessary, adding that the greatest thing by far is to be a master of metaphor. Go through all this. The associative, expressive, attitudinal, and evaluative meanings transmitted by metaphor necessarily serve as an essential part of an underlying invisible organizing principle, namely a connotative order of significance. This wider referential order also comprises legal fictions and facilitates the construction of myths, in the sense of the legal culture's conceptualization of abstract ideas and principles which appeal to an aestheticized ideal of community. Most laws are not articulated in explicit form, nor are they reflected upon by the general populace. Rather, legal dogma operates invisibly in the community, being uncritically accepted and shared by others as practical or self-evident common sense. The engendering of social feeling and a sense of partnership with others, when far from being partners or equals, elicits a compliant, self-conscious sociability, which appears to legitimate by failing to interrogate law's truth claims. Foucault describes regimes of truth in which reality is constructed historically and politically according to the singular vision of powerful institutions of civil society which control and monitor the production of discourse. Take, for example, what you were told when you got the flu shot 10 years ago. You were told you may need the flu shot for your protection. Okay? Compare that to what happens when the state says, take the shot for your protection and the protection of others. This creates a totally different dynamic in society, which takes normal people and can turn them into raving maniacs, simply with language. The individual is reconstituted in relation to a particular prevailing cultural and political ideology within which language constructs and contextualizes the social subject. Come on, get down there. Structures of power, such as law and the state, set out what is true and false, the means by which each is authorized, how truth is acquired, and the status of those determining what counts as true. And it becomes impossible to be defined outside of these discursive formulations. In this way, law's narratives of truth are manufactured via language, with the corollary that language is the site of struggle and resistance, in which the control of meaning is the winner's prize. Now, obviously, this can very easily be interpreted and probably maybe is meant as a relativist statement that if I change language, I change what is true. If I say there are X genders, then there are X genders. And this doesn't get at all into underlying truth, that there is a truth. But what I'm going to take this stuff for is language being used for power and control. And that's quite a different question from what is true, right? Let's read this bit. Ian Ward presents an eloquent argument for the inherent textuality of the law, using the example of terror and terrorism, explaining how the use of figurative allusion, hyperbole, and metaphor is fundamental to constructing the terrorist in Law Text Terror, 2009. It is suggested that the cultural embeddedness of terrorism can only be properly understood within the context of various aesthetic expressions, mythologies, fantasies, and mystical discourses. While public safety and crime prevention are legitimate aims, the implantation of Kafkaesque this will sound very familiar, cybersecurity mechanisms supported by sweeping, suspicionless surveillance and monitoring, along with the bulk interception of electric communications, is driven primarily by the concerns of government operating in an over-exaggerated and orchestrated climate of fear, rather than as a response to the actual experience or corresponding incidents of crime. Again, compare a recent experience, what your senses told you about the thing, the medical emergency, and what the government was telling you. Meanwhile, the economic capital accumulated by the knowledge industry facilitates the manipulation of reality and privileging of particular interests, which has an adverse effect on employment policies, health, welfare standards, and the social stability of ordinary citizens. Apply this to pharma, apply this to the military-industrial complex. These same forces are indeed at work. All right, go down here. Yeah, this is all good. New technologies and interests of those who own, legitimize, and control these vast networks of information are deeply embedded into what Christian Fuchs defines as structures of domination, which act as far-reaching structures of social control. It is therefore unnecessary to coerce the collective will into compliance, as people passively accept particular ideological conceptions validated by the instruments of legal authority. Whilst conceding the right of private organizations and governments to monitor and hack at will in relation to the activities of non-state sanctioned computer hacking, law relies on the metaphors of disease, for example, virus, quarantine, and inoculation. Keep in mind, this is written in 2017. Virus, quarantine, and inoculation, and criminal activity, theft, burglary, and trespass to justify a range of harsh punishments. And also, what I just mentioned, the example of protect yourself and protect others. So you are the spreader of disease. even though theft, burglary, and trespass have an ordinary meaning in the material world and are subject to a clear, albeit broad, interpretation in English law, applied to the abstract realm of cyberspace, they are often given a wider interpretation to justify harsher treatment than their more measurable physical equivalent. So take spread of disease, use the word pandemic. If you are not protecting others from a pandemic, what kind of person are you? I guess it calls for greater punishment than someone who's a gangbanger, maybe. All right, law affected rhetoric and licentia poetica. Just as the aesthetic dimension is the necessary precondition of the political, literary stratagems, rhetorical figuration, and aesthetic appeal are essential features of legal argument. In ancient Greece, storytelling was the primary method of imparting law from one generation to the next and was touted as the primary skill of lawyers, who were also expected to be excellent orators. The tradition of ars juris required an aptitude for rhetoric, abstract juristic thought, dialectical thought, and the art of conversation, as the earliest laws and customs were founded on myths, legends, and stories. Myths were often used because of their ability for telling a tale with moral import to a diverse audience, and as a cloistered profession, the legitimization of legal authority was premised on the sacral myth of perfect speech. And just try to use your imagination. Is there any myth making going on in our times? Are there certain myths about historical events that have seemed to have come out of nowhere? And these myths will then become part of legal analysis. Quintilian, in his AD 95 Institutio Oratoria, Institutio Oratoria, juxtaposed the art of law with the art of persuasion, deducing sophistry to be a necessary prerequisite of legal science as rhetoric precedes justice, aided by the employment of figurative language and tropes as a natural expression. I'm having trouble right now. And tropes as a natural extension to any literal meaning. Quintilian espoused the view that skillful oration uniquely enables the connection between idea and image, after which the next consideration is the intended audience of participants. In other words, know your listener. Okay, I'm going to have a drink of water here. He continued, as soon as we have acquired the smoothness of structure and rhythm, we must proceed to lend brilliance to our style by frequent embellishments, both of thought and words, with a view to making our audience regard the case, which we amplify as being as important as speech can make it. Style was viewed not merely as ancillary to legal argument, rather, the particular choice of rhetorical technique, metaphor, and other literary devices were forms of expression chosen to support specific content and a precise objective. So one often associates this type of rhetoric with the advocate, with the lawyer, but it also operates in terms of decision making, in the form of how the reasons of the judge are full of this kind of stuff. And also, it also plays a part in legislation. Legislation today is drafted with a lot of what we've been reading here in mind to create reality through metaphor and other devices to control how the law is perceived. I'm just going to go quickly to the conclusion. There's so much in here, but I have to get on to my point, which is trying to apply this. A few parting notes from this of interest. By constituting and being supported by state authority, legal institutions have the power to stimulate what is real in the world, determining the parameters of what is true or false, good or bad, and right or wrong, and that entirely through language. What is, as I said, what is right or wrong, what is true, that's something else. But you should at least know that it is being done, that law is not as rational and objective in itself, in its language. In its imposition of legal truths, law not only has the power to manipulate, dictate, and constrain how individuals live their lives, it also acts on the imagination by prescribing the manner in which the world must be seen and understand as through the eyes of law. These formative narratives of truth are a potent stratagem for establishing the legitimacy of legal hierarchies and maintaining structures of power, as well as having the effect of stymieing public debate and functioning as a vehicle of oppression. So literally, go back to my example, take this for yourself and to protect others. How do you argue against that? I say, well, I don't want to protect others. Well, that's the narrative you've been provided, right? So literally by choice of language and metaphor, you make it impossible to fight. This discourse of the other stands in opposition to the aestheticization of oppression, against the framing of bad laws supported by subtly coded language and imagistic references and metaphors which serve to mask inhumanity. And I will come back to this at the end. By becoming attuned to the operation of aesthetics in constructing laws, mythologies, we are better able to envisage a wider discourse of alterity and ethical judgment, and in turn pursue and reimagine other more authentic and gulp inclusive stories of law. But at any rate, this understanding power, might have some application to some things that are going on. Now let's look at something here. Let's just look at medical assistance in dying deaths in Canada. So you basically got about, between 2018 and 2020, you've got basically 19,000 people who are medically assisted in dying. Now that sounds like you're helping them, right? Medically, you're medical. So that's good. You're assisting. It's always good to help, like helping an old lady across the street in dying. Well, you can't avoid that, but you're helping them, making it nice. 10,000 people medically assisted in dying in 2021. And we don't know how many have been assisted in 2022. Why don't we look at the actual law? What language are they using here? Before we do that, let's look at some other language. Let's look at the Magna Carta. What kind of language is used here? What kind of society is it? John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou, to his archbishops, bishops, abbots, earls, barons, justices, foresters. The foresters got in there. Sheriffs, stewards, servants, and to all his officials and loyal subjects, greeting. Know that before God, for the health of our soul and those of our ancestors and heirs, to the honor of God, the exaltation of the Holy Church, blah, blah, blah. What kind of society is that? Okay. Hierarchy, religion, health of soul came before health of the body. So when in a document like this, where the king says, it's John here, to all free men of our kingdom, we have also granted for us and our heirs forever all the liberties written out below, to have and to keep for them and their heirs of us and our heirs. On it goes. But when I see when I read free men in here and liberties, it sounds like something very solid. Let's have a look at another piece of legislation. I hope I still have it. Oh, here it is. What kind of society, this is British Columbia legislation, what kind of society has a lunacy act? Probably not a society that places compassion above order and let's just say the stronger are probably ruling the society. That's my guess. And some of the language here is quite interesting. In this act, unless the context otherwise requires, judge in lunacy means the judge exercising jurisdiction under this act. And I think I might be able to make a decent case that this part of legislation has not been repealed. But anyway, I digress. Let's look at some of the language used. We just saw the numbers for medically assisted deaths in Canada. They look really, really high. Is that all consent, do you think? Almost certainly it is, right? Because the government says so. Because here it says medical assistance in dying. And then it has definitions. Medical assistance in dying means the administering of by a medical practitioner or nurse practitioner of a substance to a person. I bet that what's in that substance matters, but let's move on. At their request that causes their death, or the prescribing or providing by a medical practitioner or nurse practitioner of a substance to a person at their request so that they may self-administer the substance, and in so doing cause their own death. Again, the government is choosing certain language here with an emphasis on the medical, on health, on assistance. And of course, there's a pharmacist here. What is that pharmacist doing? Here it says, pharmacist means a person who is entitled to practice pharmacy under the laws of a province. Okay, that seems innocent enough. Eligibility for medical assistance in dying. A person may receive medical assistance. Again, that's wonderful that they're doing this. A person may receive medical assistance in dying only if they meet all of the following criteria. They are eligible. Oh, well, that's good. They're at least 18 years of age. That's good. They have a grievous and irremediable medical condition. They have made a voluntary request for this. And of course, informed consent. And just so you know, there are safeguards. So, and one of these really I find kind of interesting. For greater certainty, so when they're administering the substance, involuntary words, sounds, or gestures made in response to contact do not constitute a demonstration of refusal or resistance for the purposes of, so basically they keep going. Okay. So considering what we read about rhetoric and language and manipulation, dissimulation, what may we take from the language used here? So I think one way you can create a counter narrative, let's rewrite this and see if it has a different, this sounds very caring and loving and helpful. It's the same legislation, but I'm going to create a different narrative. What if it were written this way? State authorized killing, or SAC. Now, if it was called SAC instead of MAID, might the population have a different reaction to it? All right. The following definitions apply to this. This is my slight tweaking of the legislation. The following definitions apply in this section. State authorized killing means the administering by a state authorized doctor or state authorized nurse of a poison to a person at their apparent request that causes their death, or the prescribing or providing by a state authorized doctor or state authorized nurse of a poison to a person at their apparent request so that they may self-administer the poison and in doing so cause their own death. State authorized doctor means, it's a practicing doctor. That's good. State authorized nurse. Okay. She's a nurse. Poisoner. Well, why call him a pharmacist? Let's call him a poisoner. Means a person who is entitled to practice pharmacy under the laws of a province by which he or she has legal access to poison. Okay. Let's rewrite this section. Those pre-selected to be euthanized. A person may be considered pre-selected to be euthanized if they meet all of the following criteria. They are eligible, but for any applicable minimum period of residence or waiting period would be eligible to be euthanized, funded by a government in Canada. They are at least 18 years of age and capable of making decisions with respect to killing themselves. They are certified by a doctor, by at least one doctor, or any remotely related family member to have a grievous and irremediable medical condition. They have made a voluntary request to be killed. In particular, they aren't being forced by external pressure to do so. For further clarification, external pressure does not include being reminded repeatedly that they have a right to kill themselves when they are lonely, depressed, and feeling abandoned by society. And they give informed consent to be killed after having been informed repeatedly of the means that are available to relieve their suffering, including palliative care, and that it would be for the best. So I won't go through the rest of this, but quite clearly, one can create a very different narrative about a program like MAID by using more brutal, dare I say, masculine language. And now what's going on looks very different. And you might, who knows? You might change your views on it. Let me get out of here. So those are my thoughts today on law as an aesthetic activity, as a literary activity, as part of a form of literature, and that you cannot ignore that when you are reading legislation, when you're reading government pronouncements, and when you're considering what the government is up to. So, till next time.